We've all heard some variation of the saying, "Don't ask questions you won't like the answers to." Well, the many lawsuits against President Donald Trump's executive orders are likely to do exactly that. I predict that not only will the Democrats lose each case they file on the legal merits, those lawsuits could even save our long-faltering U.S. Constitution and destroy dozens of the most constitutionally offensive agencies in our corrupted government, including the Federal Reserve and the CIA. The irony is sharp as a razor. Let's talk about it. I am, of course, Attorney Andrew Branca for Law Self-Defense, and if you like our content, then I'd like to ask you to hit those like and subscribe buttons and ring that bell. It really helps us out, and it's free. The U.S. Constitution, the document that defines how we as a people will rule ourselves, has in recent decades been much like a high-mileage car fallen into the hands of an owner with little care and less mechanical skill. Early on, the Constitution ran smoothly. But over the years, the tires have gone bald, the oil went unchanged, and cheap Chinese add-ons ordered from Temu were bolted haphazardly on here and there without much care to how much they would diminish performance. In short, the Constitution has lost its new car smell and become a bit of a junker. And it's our own fault. Imagine then that one day our notional junker comes into the view of a lover of cars, a collector, a maintainer, a fixer, a polisher, who recognizes that under all that bolted-on trash and lack of maintenance, there lays a car that is exceptionally rare and valuable, even precious. It simply needs to be stripped of all the trash bolted onto it, given a good detailing, an engine tune-up, and it will be museum-worthy. That experience, that sudden refurbishment of the Constitution is what the American public is about to experience as the progressives launch lawsuit after lawsuit on President Trump's executive authority under Article 2 of that Constitution. I'm going to use just a few of these many lawsuits to illustrate my point. I'm not doing a deep dive on any one of them on their individual legal merits. Those are shows for another day. I felt the first hint of this realization of a rebirth of the Constitution as I was reading about the recent order of federal judge Amy Berman Jackson regarding so-called whistleblower Hammond Dillinger, a country club name if I've ever heard one. Judge Jackson, by the way, is an explicitly political judge. A self-declared Democrat who was appointed to the Washington, D.C. district by Obama, Berman has presided over many cases in which she's ruled consistently in the favor of Democrat politicians, particularly with respect to the lawsuits, many, against Hillary Clinton, and in many other cases in which she's ruled consistently against the interest of Republican politicians, particularly with respect to President Trump and his allies. In this particular case involving Hammond Dillinger, Judge Berman remains true to form. Hammond Dillinger was appointed last year by President Biden and affirmed by the Senate to the Office of Special Counsel, often described as a whistleblower agency within the executive branch. Dillinger was intended to serve a 5-year term ending in 2029, so through the entirety of the Trump presidency, and according to statute, could be removed by the president only for inefficiency, neglect of duty, or malfeasance. But on Friday, February 7th at 7:29 p.m., Dillinger received notice from the White House that he was fired effective immediately. No cause was given. This immediately stripped Dillinger of access to his office, emails, and all the other typical lockdowns of a firing. The following Monday, Dillinger filed a lawsuit with Judge Berman's court. He said his firing was unlawful based on the statutory requirement that he could only be fired for inefficiency, neglect of duty, or malfeasance, none of which was a reason given to him because, as I just said, no cause was given at all. He asked Judge Berman for an immediate temporary restraining order restoring the status quo, meaning putting him back into his office, including full authority and access to everything that he had been locked out of. The response of the Trump White House is that the congressional requirement that removal for cause is necessary is unconstitutional because Congress lacks the authority to set limits on the core and plenary powers of the executive branch. Doing so is a violation of the constitutional doctrine of separation of powers, and therefore null and void. Judge Berman then wrote an order consisting of several pages of weak legal reasoning, trying desperately to distinguish prior Supreme Court decisions that explicitly stated that removal only for cause statutes imposed by Congress on the president are unconstitutional, only to conclude that none of that really matters. Why doesn't all that law matter? Because, Judge Berman writes, quote, "The Office of Special Counsel is an independent agency," close quote. Therefore, by her reasoning, because the office is an independent agency and not really part of the executive branch, it's okay, in Judge Berman's view, for Congress to impose conditions on the president's executive branch authority. But here's the thing, folks. Judge Berman does not get to define what the structure of our government is. Not even the U.S. Supreme Court gets to do that, or Congress, or even the president. Only the Constitution gets to define how our government is structured, and there is not one word in the Constitution saying a thing authorizing independent agencies. We have 3 branches of government. Count them, 3, only 3. The Article I legislative branch, the Article II executive branch, the Article III judicial branch. These are each 3 separate branches of government, with each designed for obviously distinct purposes, and with each possessing its own core and plenary powers on which the other 2 may not infringe other than as explicitly permitted by the Constitution. And every function of government in any well-ordered society based upon the collective will of the people operating with a constitutional structure must fall within one of those 3 branches. Every government agency must be answerable to one of those 3 branches of government, which are in turn answerable to the body politic, us, as defined in the Constitution. There is no 4th branch of government in the Constitution called independent agencies, independent of any of the 3 branches, and thus utterly unmoored from being checked by any political will of the American people. So if you wish to follow the actual Constitution, not only are the limits on Hammond Dillinger's firing unconstitutional, the entire Office of Special Counsel is unconstitutional as an independent agency because it sits outside the 3 branches of government, which are all the Constitution allows for. Standing outside the 3 branches of government, the Office of Special Counsel is entirely unmoored from our constitutional order and literally cannot possess any governmental authority or presence at all. By the same straightforward and inescapable reading of constitutional law, the Consumer Finance Protection Bureau, also currently being protected by Judge Berman from firings demanded by President Trump, also described as yet another independent agency, is also inherently unconstitutional because it sits outside the 3 branches of government that define the entire allowable scope of our constitutional governance. And for those of you who have long wondered what the heck exactly the unelected Federal Reserve is, why do we allow it to control the money supply of the United States, and where within our constitutional order can its foundation be found? The Federal Reserve is yet another independent agency that is also inherently unconstitutional because it sits outside the 3 branches of government that define the entire scope of our constitutional governance. In fact, there are almost 60 agencies that are considered independent agencies and thus are apparently unconstitutional. At least one of these has become famous in recent weeks as a vast ocean of waste, fraud, abuse, and graft, and that's the USAID. Others are better known to the public and have particularly nefarious reputations. I've already mentioned the Federal Reserve, but guess what? Another one of these independent agencies is the Central Intelligence Agency. That's right, like every other so-called independent agency, neither the Federal Reserve nor the CIA have a sliver of constitutional basis for their authority or even their existence. So how were these so-called independent agencies allowed to be created? Well, much of this damage began during the FDR New Deal era, when the American body politic was thoroughly stricken with societal cancer and struggling with first economic depression, and then war. Simply put, our ambitious political class took advantage of the distraction and inattention of our electorate at the time and have continued doing so ever since. The Constitution, by design, is intended to constrain government power, scope, and authority and protect individual liberty from government overreach. That's why the entire Bill of Rights consists on limitations on government authority. The founders had, after all, just won a desperate war to secure their liberty from a tyrannical king. And at the risk of their very lives, their fortunes, and their sacred honor, with many of the signers of the Declaration of Independence ultimately suffering great personal destruction. As George Washington himself noted, quote, "Government is not reason, it is not eloquence, it is force. Like fire, it is a dangerous servant and a fearful master. Never for a moment should it be left to irresponsible action." Government, of course, is really just made up of people. But inherently, these tend to be the politically ambitious people in our society who wish to exert authority over others, because with authority comes power, wealth, and control. And such politically ambitious people chafe at a constraining constitutional structure because it prevents them from exerting over others the control that gives them power and wealth. So if the American people happen to look away for a moment, perhaps because they're just struggling to feed their kids or survive a world war, the politically ambitious surreptitiously click the ratchet a bit further in the direction of diminishing their constitutional constraint. And if they do it slowly enough, boiling the frog, or some occasional crisis allows a brief window of abrupt change, then the citizens hardly even notice the power of government being inexorably expanded and their own liberty eroded. But this incremental increase in government authority at the cost of your liberty isn't to be found in the design of the actual Constitution, except by the process of constitutional amendment under Article 5. Instead, it's just been kind of bolted on, bit by bit, like the trash parts were bolted onto the notional car I mentioned at the beginning of today's show. A bit of trash bolted on here, a bit of trash bolted on there. And eventually what had been a nicely running and aesthetically pleasing car is turned into a junker. But the real car of value, the hidden museum quality vehicle, is still there. It just needs to be seen by the right set of eyes. The eyes of someone who is informed about what that obscured vehicle should properly look like with the trash stripped off. And the eyes of someone with a genuine love for that obscured vehicle and the museum quality work of art it could be once again with just some tender loving care. And most of that tender loving care will be to strip off and toss away every component that is not, in fact, a designed component of the actual Constitution. And that's what we in America must do politically. We must drive the stripping off and tossing away of every component of our federal government that is not actually in the Constitution, or reform them to be within one of the allowable branches of government. And that certainly includes every single one of these so-called independent agencies lacking any mention or explicit purpose set forth in the Constitution, including, as noted, the Office of Special Counsel, the Consumer Finance Protection Bureau, the Federal Reserve, the CIA. All of these so-called independent agencies are found nowhere within our defined constitutional order. They stand alone and apart as a claimed co-equal or even a superior, mysterious fourth branch of government that is an utter constitutional fiction. And they're effectively unanswerable to the American body politic until, that is, they are seen for the constitutional monstrosities they are, as is about to start happening today. But why today? Why do I think that now is the moment for the public to begin to realize the need for a proper refurbishment of our beloved Constitution when we haven't had that collective realization for decades? Because today, the progressives of our society are forcing us to ask the questions that I expect they will not like the answers to by bringing this tidal wave of lawsuits against President Trump's executive authority. These lawsuits force us to really look at these so-called independent agencies and then inevitably, inescapably, to realize that these so-called independent agencies simply aren't allowed for in our Constitution and are therefore inherently unlawful and utterly without lawful power. These petty lawsuits brought against President Trump for mere near-term political advantage are going to open the eyes of the American people to the constitutional debasement that has been underway for decades, to the benefit of the government seeking power over us, and to the detriment of our individual liberty. The lawsuits raise questions that I don't think the progressives are going to like the answers to even one little bit. The debasement of our Constitution ends right now. And ironically enough, it's the progressives who most wish for greater power over us who are themselves knocking out the foundation of their means of oppression. Let's not let this opportunity to peaceably re-seize our liberty pass us by, folks. The historical record suggests such opportunities arise only every few hundred years, and usually they require that a desperate war be fought. And that's all I have to say about that for the moment. I'll close up by reminding all of you that if you like our content, then I would simply ask you to click that like, subscribe button, ring that bell. It's free and it helps us out a great deal. Until next time, I remain Attorney Andrew Branca for lawofselfdefense.com. Stay safe. Hey folks, I want to take just a moment to invite you all to our upcoming live and 100% free Law of Self-Defense Hard to Convict webinar. This free webinar teaches you how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. The webinar is live streamed by me personally, and there's plenty of opportunity for Q&A. Best of all, it's 100% free, but we do limit seats to allow for adequate Q&A. So I urge you to grab your seat right now by signing up at lawofselfdefense.com/hard to convict.